Ever seen those dramatic courtrooms in Bollywood movies? The intense stare downs, the suspenseful music. But let me tell you, real life courtrooms aren't exactly a film set. When it comes to transferring inherited properties to NRIs, the process involves legal terms and laws, and there's no need to worry about any legal drama. I've got your back. In this video, I'll talk about what does inheritance mean, from whom can an NRI inherit property, how to transfer inherited properties, and finally, the documents required for a smooth transition. And for those familiar with Groww videos, you know we love to sneak in a bonus section. This time, I've scattered extra information touching on inheritance laws and property types that an NRI can inherit. Wait, I'll let you find those gems. Now let's start with the basics. What does inheritance mean? Inheritance is the legal process through which ownership and rights to properties, including titles, deeds, associated assets, are passed from a deceased individual to their designated heirs, which may include NRIs. Now there are two ways this handover happens. The first way is testamentary succession, which refers to the legal process of inheriting property as per the wishes specified in a valid will or testament left behind by the deceased person or testator. The transfer of assets occurs based on the instructions outlined in the will, including details about beneficiaries, their respective shares, and any specific conditions. The second way, intestate succession, occurs when a person passes away without leaving a valid will or a testament. In such cases, the distribution of the deceased person's assets, including property, is governed by the applicable laws of the intestate succession. These laws vary depending on the individual's background, such as the Hindu Succession Act 1956 or Muslim law. The distribution typically follows a predefined hierarchy of legal heirs in the absence of explicit instructions in a will. Now, what does transfer mean? Under Section 2ZE of FEMA, this term transfer includes sale, purchase, exchange, mortgage, pledge, gift, loan, or any other means by which rights, title, possession, or lien are transferred. I'm guessing by now you've understood what inheritance and transfer mean. Now let's talk about the laws that govern inheritance. In India, your wealth's journey after you is directed by specific laws, and for NRIs, it's a bit like decoding a treasure map. The two key laws I'll discuss today are the Indian Succession Act of 1925 and the Hindu Succession Act of 1956. Have you ever seen a Swiss Army knife? The Indian Succession Act of 1925 is the Swiss knife of inheritance laws covering everyone except Hindus, Sikhs, Jains, and Buddhists. This act allows the registration of wills, facilitating the transfer of movable or immovable property under India's property inheritance laws to a designated individual, whether a family member or otherwise. Let's face it, life doesn't always come with a script. In the absence of a valid will, the inheritance of assets for an Indian citizen varies based on their religion. For Hindus, the Hindu Succession Act 1956 applies, while Christians, Parsis, and Jews follow the Indian Succession Act of 1925. Additionally, individuals identifying as Buddhists, Jains, or Sikhs are considered Hindus in terms of personal laws. Those outside the Muslim, Christian, Parsi, or Jew categories are also subject to Hindu laws for property succession. A notable development is the 2005 amendment to the Hindu Succession Act, bringing about a significant change by granting equal rights to daughters in ancestral properties. This amendment reflects a substantial step towards gender equality, securing daughters' recognition as equal joint heirs in a Hindu undivided family. Now that you've understood the basics of inheritance laws, let's take a closer look at the maze of property types and how these laws play out. Ancestral property. Ancestral property, as the name suggests, is the land or property that belong to your ancestors. If you're the legal heir or a deceased property owner, you inherit it as ancestral property. The Hindu Succession Act of 1956 helps us categorize these ancestral properties into joint and separate ones. Now let's tackle how you figure out if your property is ancestral. The key is to figure out 4 generations of the male lineage. So imagine A has property, his son B, grandson C, and great-grandson D all have the potential to inherit it. It's like passing down a property legacy. But here's the twist. To keep it ancestral for these 4 generations, the property distributed must stay undivided. If A splits it equally among multiple children, it loses its ancestral charm and becomes a self-acquired property of individual heirs. Self-acquired property. It's a property an individual buys with their hard-earned money. Picture it like this. You work, you earn, and you have gotten this property, so you are the undisputed owner. Now here's where it gets interesting. Imagine an ancestral property, the kind that's passed down through generations. When it's divided among family members, each person gets their share. This is where the ownership shifts from being ancestral to becoming self-acquired. But hold on, our legal drama doesn't end there. Let's see what FEMA and RBI have to say in our next segment. We need to know two things when it comes to NRI inheritance. First, what type of property can NRIs inherit? NRIs can freely purchase residential or commercial properties in India, but they are restricted from buying agricultural land or farmhouses. However, they can inherit or receive these properties as gifts. To inherit, whether from a resident or a non-resident Indian, the property's acquisition must align with foreign exchange laws and FEMA regulations. The RBI, acting under the FEMA Act, oversees all of these foreign exchange transactions, and acquiring property without RBI's permission requires specific approval from NRIs. Second, from whom can NRI inherit property? NRIs have the legal right to inherit property from both residents and non-residents in India. However, when it comes to properties inherited from non-residents, certain conditions under the Foreign Exchange Management Act must be adhered to, ensuring compliance with foreign exchange laws. How to transfer inherited properties? NRIs have two main routes to transfer inherited property in India. First, voluntary transfer. Owner willingly transfers property through sale, mortgage, lease, exchange, will, inheritance, or gifting. Second, involuntary transfer. The court takes control without the owner's agreement. This happens when legal obligations like settling financial debts necessitate a transfer even without the owner's consent. Now, how is this transfer done? In involuntary transfers, the court of law holds authority, while in voluntary transfers, the procedure varies based on the type of transfer. Before moving on, listen to what FEMA has to say. For starters, any transfer of property to NRIs and PIOs must comply with the Foreign Exchange Management Act. The person transferring the property should have also acquired it in compliance with FEMA regulations or any other foreign exchange law that's in force at the time of acquisition of this property. If inheritance is in favor of a foreign national, permission is required from the RBI for the transfer. Let's start with the first way to transfer inherited property, which is a will. Will. Many Indians work hard to build wealth for future generations, but without a will, the transfer of assets becomes complicated. NRIs especially face the challenge of identifying assets, dealing with extensive paperwork, and navigating a very complex process. For a seamless transfer of assets, it's essential to have a well-drafted and registered will. Now, when crafting a will, move beyond a mere listing of assets and consider these guidelines for drafting an effective will. First, simply stating all my assets go to X family member in a will is good, but is it truly helpful? Without detailing the assets, your family may not know what's included, leading to potential loss in the unclaimed pool. Just to drive the point home, recent data reveals a 28% surge in unclaimed bank deposits, reaching 42,270 crore rupees as of March 2023 compared to 32,934 crore rupees in the preceding fiscal year. Second, consider the objectives of your will. Beyond seamless transfer, think about planning for potential health issues, controlled asset distribution over time, and protection from financial exposure through trusts. Generic templates from the internet may not suffice due to the unique complexities of each family. Consulting experts ensures practical insights tailored to specific family dynamics. Third, factors such as the place of demise, usual residence, and the intent to establish permanent offshore residency can influence inheritance tax implications. Becoming a deemed domicile in a foreign jurisdiction may trigger inheritance laws there, potentially affecting Indian assets. Fourth, communication is key. Even if family dynamics complicate issues, at least someone should be aware of the will's existence for a smooth transfer. Lastly, a small tip: involve a financial planner in the will making process. While lawyers understand the legal aspects, financial planners bring insights into each asset's characteristics and the optimal way to transfer the property. This collaborative approach enhances the effectiveness of the will. We've covered drafting a will, but registering the inherited property is equally crucial, and specific documents need verification by the sub-registrar for attestation. This process is governed by the Indian Registration Act of 1908. For will registration, you'll need passport-size photos, a mental soundness certificate, the original signed will, an ID, residential proof for the testator, and 2 witnesses with their passport-size photos and PAN cards. Please feel free to pause this video to take a screenshot of these documents. The second way to transfer inherited property is intestate succession. In the event of an NRI passing away without a will, the inheritance process becomes a paperwork shuffle. When someone passes away without a will, the Indian Succession Act governs the transfer of their assets. Recollecting what we've understood earlier in this video, for Hindus, Sikhs, Buddhists, or Jains, it's the Hindu Succession Succession Act of 1956. Christians and Parsis follow the Indian Succession Act of 1925, and for Muslims, it's the Muslim Personal Law or Shariat. Now, to prove you're the rightful inheritor, you'll need documents like birth and death certificates, purchase deeds, and bank papers. And to make it all legit, the legal heirs need to agree, and they usually sign an affidavit, sort of like a family agreement. The property shares are then divided based on how many legal heirs are there in the game. It's like dividing the pizza slices but with paperwork. Whether you inherited the property with or without a will, NRIs must register the property with an appropriate sub-registrar for assurances to officially transfer ownership post-inheritance. This process involves paying the applicable registration fees as per the state-specific Registration Act and submitting additional documents such as the death certificate of the deceased person and no objection certificate or NOC. If the documents for will and intestate succession confused you, take a screenshot or pause the video to check this image. According to Section 122 of the Transfer of Property Act 1882, any immovable property can be transferred through a gift deed. It's similar to a sale deed, but in this case, no money is exchanged. The gift deed must be registered with the Sub-Registrar Office under Section 17 of the Registration Act 1908 and as per Section 123 of the Transfer of Property Act. Now that we've understood how NRIs inherit property through gifts, let's outline the steps involved in drafting a gift deed for immovable property. It might sound a little bit legal, but don't worry, I'm here to make it sound simple. Step 1. Be clear with who is the donor, the recipient, and of course the property itself. Step 2. It's time to put pen to paper, but not just any paper. Get a lawyer or a property expert to help you draft a gift deed. We're talking about the document that makes it all official. Throw in all the details like describing the property, talking about what's in it for the giver, and lay out the do's and don'ts for both parties. Step 3. Once your document's ready, it's time to print it on non-judicial stamp paper. Step 4. Gather the squad. Sign the document with 2 witnesses. Step 5. Take your official paper to the local sub-registrar's office to get it registered. Of course, there's a small fee for this step, so be ready to chip in. Step 6. Pay the stamp duty and registration fees. It's the backstage pass to make everything legal and official. Step 7. Hold on to your paperwork. Get a receipt and copies of the registered gift deed for your records, just in case someone asks. And there you have it. After all this, the property title officially shifts to the receiver's name. They become the new owner of the property and you've successfully passed on the ownership title. Now that we've explored how NRIs inherit property as a gift, let's see the registration process for gift deeds, because failing to do so will render the contract invalid. The gift deed registration involves a bit of paperwork like the original gift deed document, proof of ownership of the property being gifted, ID proof of both the donor and the recipient, and the latest property tax receipts, among other documents. It might seem like a bunch, but think of it as a path to making everything official and above board. And hey, remember that the mentioned documents can vary based on your state and jurisdiction in India. That was a lot. Understanding that inheritance and transfer are 2 different terms and how the laws govern the inheritance, I get you. Let's do a quick recap of today's video. Inheritance and transfer are 2 different terms. Inheritance deals with the passing on of property upon someone's demise. On the other hand, transfer covers a range of activities. This includes changing property ownership, whether through inheritance or other legal transactions. Inheritance is divided based on whether you have a will or testamentary succession and no will or intestate succession. There are 2 laws you must know: the Indian Succession Act of 1925 and the Hindu Succession Act of 1956, alongside specific succession laws for other religions. NRIs have 2 main routes to transfer inherited property in India: voluntary transfer and involuntary transfer. Within this, you will have will, intestate succession, and gift. That's it for today's video. Like and subscribe if you found this helpful. I'll see you in the next video. Bye-bye.